I would now call on Onojeghuo. Onojeghuo is the Chief Executive Officer of Onojeghuo. He's a fellow of the Information Privacy, Certified Information Privacy Professional, Manager and Technologist with a Master of Laws in Internet Law and Policy, LLM. She has a unique mix of experience that embraces IT, quality assurance, data protection, compliance, and organizational change management. Ito is a privacy evangelist who has been instrumental in determining solutions for process improvement, strategic planning, and policy development. She has strong technical skills and extensive experience in the deployment of a variety of systems and procedures to meet business and regulatory compliance requirements. She currently works with a number of global establishments as an independent data protection consultant, group data protection officer, and EU representative with strong knowledge and experience of privacy and needed um, related laws across various jurisdictions, including the UK's Data Protection 2018, GDPR, CCPA, NDPR, and HIPAA. Ito is going to tell you what this all this means. Ito advises on cross-border data transfer mechanisms and supports business in making strategic decisions to ensure compliance with processing of personal data and rules relating to the free movement of personal data. Ito is also accredited training partner for the International Association of Privacy Professionals, IAPP, and provides training on an IAPP's professional privacy certification, CIPM, and CPT. Ito is going to talk on cross-border data transfer mechanisms and the requirements of an EU or UK representative. Ito.
Thank you for the kind introduction, Esosa. It's my pleasure to speak on this topic, this relevant topic, of course, with Maurice that has just spoken. Thank you, Maurice. And Brian, thank you. Yes, absolutely, Maurice. Data has become really valuable, as Esosa added, maybe more valuable than silver and gold, and if I may add, more valuable than oil. With the exponential rise in the use of the internet over the last, well, let's say 20 years, this has led to new and updated data protection related laws. Maurice mentioned a few of them, GDPR, PIPEDA, Nigerian Data Protection Regulation, and so on. So indeed, we should be aware of the rules we must follow. Talking about the rules, we need to think about the principles of data protection, talking about purpose limitation, data minimization, just collect what you need, and so on. And also the lawful basis for processing. Are you legally required? Can you justify why this data is being collected? I'm not going to go into much detail, but when we talk about lawful basis, an example is, have you received adequate consent for processing that information? Or are you depending on relying on contracts or legitimate interest, whatever the case may be? And also, have you considered the rights of the data subjects? Yes, as Maurice mentioned, GDPR is indeed the most stringent and therefore could be used as the benchmark for data protection regulations around the world. Yes. So with the UK's exit from the EU, certain rules are applicable for free cross-border flow of data both ways. It's not just a case of both ways in terms of data leaving the EU. We should also consider data leaving the UK as well. So businesses need to demonstrate accountability, respect the rights and freedoms of individuals, and of course, avoid the consequences, avoid fines. Yes, over the, the last 2 years, I've been, 3-4 years, I've been extremely busy working as a group data protection officer for global organizations. And I would say it's as a result of the GDPR, from preparing for the GDPR, that I would say businesses have become more interested in it. Obviously, the main thing is mainly, apart from to avoid reputational damage, but basically to avoid fines, so to speak. Maurice talked about the penalty. Under the GDPR, there's a 2-tier penalty, and also under the Nigerian Data Protection Regulation as well. So I haven't actually started. So I'm told we have 20 minutes each to give key insight on Brexit and data protection, particularly on how companies can comply with data privacy and data protection laws whilst ensuring business continuity. This is quite a bit, there's quite a bit to cover on this, but I promise not to make it a lecture. I'll just cover 2 points specifically relating to corporates, so businesses. Yes, so number 1, I would cover the data transfer landscape. Essentially, what are the options for transfer out as a third country, to a third country, so outside of the EU or maybe outside of the UK, indeed outside of Nigeria as well, if you're looking into the Nigerian Data Protection Regulation. Yes. Number 2, the requirements of EU and UK data protection representatives. Okay. So in just 2020, the number of proposals and changes in EU privacy laws, not just pertaining to Brexit, should I say, created a pandemonium in the privacy world. There were lots of speculations. Even the EDPB, the European Data Protection Board, had suggested delays, which has eventually happened, suggested delays with respect to an adequacy decision made on the UK. I'll talk about adequacy decision shortly, made on the UK because of the suggested international agreements with the US. Then, of course, the Brexit transition period ended on the 31st of December. So after a worrisome period of wrangling, British and European negotiators, well, there was a decision. However, not yet a conclusive decision. That's what we need to know. Now, the trade and cooperation agreement signed between the EU and the UK on December 24th provides a temporary grace period for data flows to continue between the EU and the UK. So we're still okay. Data transfers from business and law enforcement purposes can continue until adequate decisions are being made. So should I say the agreement includes the bridging mechanism. And of course, this buys privacy professionals, this buys us time working with our business partners, with our clients, a little more time for handling data transfers. So number 1, I said I was going to talk about just 2 points. So number 1, data transfer landscape. Essentially, this is what we're saying here is, what are the options for international data transfer? There are 3 main routes to transfer data outside of the EEA under the GDPR. Remember, we're using the GDPR as a benchmark. So there are 3 main routes to transfer data outside of the EEA. The EEA is the European Economic Area. That's made up of the EU member states, that's 27 EU member states. So plus Liechtenstein, Iceland, and Norway. Of course, we know the UK used to be one of these. So there used to be 28 member states. So there are 3 main routes to transfer data out of the EEA to third countries or international organizations. So the 3 ways: number 1, adequacy decision; 2, appropriate safeguards; and 3, derogations. So the main thing here is that if you are working with a business in the EU, if your organization is working with a business in the EU and you're concerned about how data could be transferred to your country, and if it's not regarded as, if it's not in the EEA, then what are your options? Number 1, adequacy decision; 2, appropriate safeguards; and 3, derogations. With the first, that is adequate decision, being the preferable option. So adequacy decision, what is this? With adequacy decision, there's no additional authorization for transferring data. Rather, no additional authorization for transferring data is required. So transferring data from the EEA to a country regarded as being adequate. The adequate decision, by the way, is one that is made by the European Commission. So transferring data from an EE member state to an adequate country is just as good as transferring within the EEA. So of course, if you're thinking, so when working with an organization, the first thing to think about, number one, is are they part of these adequate countries? The European Commission has so far recognized 12 countries as providing adequate protection. So these are Andorra, Argentina, Canada, that's for commercial organizations, Faroe Islands, Guernsey, Israel, Isle of Man, Japan, Jersey, Nigeria, sorry, I didn't mean that, New Zealand, I was just kidding, Nigeria is not part of it, and Switzerland and Uruguay. Yes, and a special arrangement with there was a special arrangement with US organizations up until July 2020, when the EU-US Privacy Shield was invalidated. So adequacy talks are ongoing with South Korea, and of course now with the UK. Remember earlier, I talked about the 6-month period, extended period. So conferring, since we're thinking about the UK now, we're hoping for that the UK will be regarded as adequate. That would make things a lot easier, and I see no reason why not. So conferring an adequate decision on the UK will require a proposal from the European Commission and an opinion from the European Data Protection Board. And so there are certain criteria they look into before making the decision, the adequacy decision. So let's see, I'll just give a few of these criteria, and then you will see why, depending on, I'm sure in terms of the audience we have here, we're from different countries. So if you're not on the list of 12 that I mentioned earlier, then you may be able to tell why your country may not be regarded as being adequate. So what has been looked at is the respect for the rule of law in the country, the access to justice, international human rights standards. Let's just talk about how democratic the country is, then effective and enforceable rights for individuals, then having the data protection rules, the professional rules, and security measures. Mind you, of course, we know so many countries have these rules, but at the end of the day, how practical, the main thing here is that we also need to think about how effective or enforceable the rules are. Yes, so we could say that based on this criteria, we can say that the agreement would paves the way for adequacy for the UK. Now, but what about transfer of data out of the UK? That's a question. Well, simple answer here. The UK has already deemed the EU and the EEA member states to be adequate for the flow of data from the UK. Okay, and another question for me again is, and what if after this extended 6-month period, the UK is not deemed adequate? Well, that's not going to be the end of the world. That would then lead to the need to consider other options. And that would take me on to the next, which will be appropriate safeguards. So simply put, in the absence of an adequacy decision, which is the best option, controllers and processors, so controllers will be the organizations that determine the purpose and the means of processing, and then the processors are the organizations that act on behalf of the controllers. Controllers and processors can rely on appropriate safeguards for data transfer, particularly where transfer is required on a regular and ongoing basis. Okay, so quoting the UK's Information Commissioner, I quote, a sensible precaution before and during this period, businesses should work with the EU and the EEA organizations, now I'm paraphrasing, who transfer personal data to them, to put in place alternative transfer mechanisms. That is to safeguard against any interruption to the free flow to EU of the personal data. So yeah, so that's kind of what we're talking about now. What in the event that there is no adequacy decision granted for the UK, what do we do? So there are a number of options, and under the what we call the safeguards. So the key thing here is to think about what would be most suitable to the organization transferring or receiving data. So what do you rely on? One of the options, so it's not a case of, oh yeah, outside of the EEA, we cannot transfer data to you. One of the options would be to rely on what they call the standard data protection clause. So these are standard contractual clauses adopted by the European Data Protection Board and the supervisory authorities. So it could be used without further formal approval. These clauses are available, and this document, so to speak, is available. You can download it from any of the supervisory authority websites. So in the UK, you've got the the ICO, Information Commissioner's Office. In France, you've got CNIL. In Spain, you've got APD and all that. They all use the same document, but of course, let's look out for the updated version. Yes, so with this is the quickest way, the most straightforward way. So we don't have to wait for 6 months. So basically, you can have a standard data protection clause between controller and controller, or controller processor, however, and it's more like an agreement. Yes. So that is one way. That, of course, again, it depends on the type of processing. Now, for some organizations, the standard data protection clause may not be perfect, may not be suitable. And so such organizations may decide to draft their own, should I say, ad hoc contractual clause. That's fine. But with that, because you need to have that approved by supervisory authority. And then once approved, that could be relied on. Another mechanism is the binding corporate rules. So this is for intra-organizational transfer. So whereby you want to, for multinationals, where you have not just multinationals within the EU, you've got maybe headquarters in the US, you've got a branch in Brazil, Nigeria, and so on. So for this intra-organization transfer, what we're talking about is transfer within the same entity, so to speak. So not external, within the same entity. So because, mind you, even for organizations that are within the same entity, you have the headquarters in the US, you need to ensure that data is being transferred to the headquarters lawfully. And so this could be some arrangement. However, it requires approval by supervisory authority, but provides flexibility following the approval. Over the last about 6-7 months, I've actually drafted some binding corporate rules for 3 global organizations, and we're still awaiting approval, because the main thing here, it's a binding corporate rule. So it's not just a matter of drafting a document and signing. The main thing is that each of these entities would need to comply, and so some investigation would need to take place before the organizations, before approval, so to speak. So let's see how it goes. So then there's also, this is kind of new under the GDPR, the certification mechanism, whereby you have accredited bodies that could then certify, should I say, audit and certify organizations. It's similar to, when I'm sure you're aware of, most will be aware of the ISO standards and so on. So basically, it's more like having a data protection certification stamp, so to speak. The France had since been working with certification mechanism, but this is kind of this practice recently is new under the GDPR, and in fact, it's basically new under the GDPR. I try not to go into too much detail. Yes, and in fact, okay, and NIDA, that's in the Nigerian General Data Protection Regulation actually offers something similar, the certification mechanism as well. Then we also have the approved codes of conduct. So just like any other codes of conduct, it's a matter of including some data protection clauses with regards to international data transfer. So these are examples that could be relied on in the absence of an adequacy decision. Like as I mentioned earlier, when we rely on with the appropriate safeguards, so appropriate, which of these would be most appropriate for the cross-border data transfer, it's a matter of checking to see what exactly is most suitable to the organization, depending on the type of processing or transfer required. Yes, so what next? What if you're a small business and you don't transfer data on a regular basis? You're not within located in a country deemed adequate. Does that mean you cannot receive data from the UK or EU? No, that's not the case. So in the absence of an adequacy decision or appropriate safeguards, derogations may be used for international transfers. These are somehow more relaxed options and more appropriate, usually recommended when transfer is not regular. So example of this would be explicit consent, relying on explicit consent, that's the consent of the data subject, the individual whose data has been processed. Again, this has to be dealt with on a case-by-case basis. You sometimes, depending on if you're relying on consent for transfer of maybe staff data, your employee data to another country, that may be regarded as being invalid. I wouldn't mention the name of a well-known organization, but a well-known global establishment was recently fined for this, for transferring data for whereby the use of consent for transferring employee data was regarded as invalid, so to speak. So something else that you could also rely on performance of contracts with a data subject. So I'll give an example, a very just basic example, so whereby organizations could rely on either consent or performance of the contract. Remember, I've mentioned here when we're talking about the derogations, is best for when, or should I say, it's more suitable when the transfer is not that, when the transfer is occasional. So if you were to be maybe a travel agency, a small travel business, a travel agency, and you want to maybe arrange some bookings for your clients in a country that is not regarded as being adequate, or you don't have any standard contractual agreement with the other party. And so basically this sort of transfer may be on a one-off basis, whereby each time you get a request, then you maybe make arrangements with a company at the other end, and I find out a company that maybe provides maybe car hire service. You're not expected to sign a standard contractual clause with such a company, but you could then rely on explicit consent. So identify, ensure you mention to the data subjects the risks that could be as a result of maybe transferring the data, since it's to a country that is not does not have the same standard as maybe the UK or the EU, and for them to agree that to consent to sharing such data. Or again, it depends. You could rely on the performance of contracts with the data subject, with the individual. So another example of derogations would be whereby transfer may be required based on public interest recognized by the member state's law or the EU law. Then another would be protection of vital interest. So vital interest, the way I explain it is just think about common sense approach, do or die affair. If you need to share data to maybe save someone's life and the individual is not in a position to give consent, maybe for health reasons or whatever the case may be. It just depends. So sometimes we might be able to rely on vital interest. Then again, another option is could be, or when you could rely on some form of derogation, is transfer from a public register. So not just a register. So if some information is available in a public register in the EU or in the UK, then that information could be shared as well. And not lastly, the other ones, but the last point here I would be thinking about is legitimate interest of the controller. So with legitimate interests, now under the GDPR, when relying on legitimate interest is one of the lawful bases for processing. There are 6 lawful bases for processing under Article 6 of the GDPR. So when relying on legitimate interest, a data controller needs to do an assessment, a legitimate interest assessment, LIA. So they need to first think about the purpose for processing that data, and then the necessity, how necessary is this method, and are there other methods that could be used that may be less intrusive? And then finally, balancing. So balancing the interest of the controller against the interest of the data subject. So to ensure that the controller respects the rights and freedom of the individual, or ensure that there's no risk to that individual. So usually when transferring within the EEA, within the UK, that's usually fine. But of course, even data controllers would have to have this documented. So it's not a case of a business, maybe someone reports to the supervisory authority and states that their information, maybe they were marketed to unlawfully without giving consent. And then the business then says, well, we relied on legitimate interest. It's not just that, you need to show evidence of the assessment, so it has to be documented. In fact, an organization, a tennis club association, was recently fined over €500,000 because they shared data of their members with sponsors, and then they stated that well, we relied on legitimate interest, but that's of course not the case, because they would have to show evidence. But not just that, would legitimate interest was not the right option. In that case, they should have relied on just consent. But my point here is that when you rely on legitimate interest within the EEA, that's even quite simple, in the sense that you don't have to get formal approval. You do your assessment, of course, check with experts that it's right. And then, but when relying on legitimate interests for cross-border data transfer, the controller would need to inform the supervisory authority. So let's say in this case that this is more like some kind of approval. So that, because if not, that would be the simplest thing to do. Every organization relying on legitimate interest to transfer data.
Hi, Ito, may I interrupt you? How long do you have to go?
Well, I would say possibly 5 minutes.
Okay, because we still have Brian, and then
sure, absolutely.
I'd like to have other people also contribute. Thanks.
Okay, thank you very much, Neil. Thank you.
Thank you.
Okay, so that's about that with the first point, talking about the landscape, the data transfer landscape. So when we talk about adequacy decisions, and derogations and safeguards. So the next point I would like to talk about is working with EU representatives. So there's the obligation to designate a representative in the EU. So the obligation remains the same. There's always been that requirement for some organizations. So organizations not established in the EU that offer goods and services or monitor behavior of data subjects in the EU may be required to appoint an EU or UK representative. So this is not just a case of this is now for organizations that are outside of the EU or providing services. Now, for this, the representative needs to be established in the EU. So this is now with the UK and with Brexit, some UK organizations that have been acting as representatives, there may now be a problem. There would now be a problem. And so it's very important that if you're working with a representative, then the representative kind of acts as a data protection officer for the business, as long as they're based in the EU. So it's something to look out for if you already have a representative. Just to say, for example, like Onojeghuo, our company, we also act as EU representatives. And of course, this created some opportunity in the sense that we knew we still had to serve our clients. And so we are established both in the UK and in the EU. So it's business as usual. Yes. So this is just something to consider. And that does help. So you don't have to be based in the UK or in the EU. You could also have a representative work with you. There are some exemptions whereby you don't have to have, it's not all the time you need a representative, but I wouldn't go into details just because of time. So yeah, so in conclusion, the preferred and what we hope is to have the UK be amongst the list of adequate countries, but otherwise there are other options businesses in the UK can rely on to carry on with business as usual. Indeed, organizations have 6 months to get prepared. Yeah, so I guess at this stage, I would hand over to Esosa and would be happy to answer any questions at the end. Thank you very much.
Thank you very much, Ito. That was very, very insightful and educative. I'm sure a lot of us, some people who are not lawyers here would not say, what does that have to do with me? It's so technical, but very vital and very important. We cannot stress it enough. GDPR is the most stringent and also it's a benchmark for all handling of data protection and privacy. Ito has talked about processing, processors, and controllers. They're technical, but it's about the handling of information and handling of information within your border and outside of your border. And the EU has a benchmark for that. And by law, you are meant to comply with it. Ito has told us about the safeguards and the derogations that are necessary for it. I'm sure a lot of people will be asking you questions during the Q&A session. But what she's saying is, even if you are a small business, you need to comply